Hi, this is Ed Sullivan and Mark Oberti with another Oberti Sullivan podcast. Mark, a lot of executives have employment agreements, and it says they can only be fired for just cause. What does that provision mean?
Well, the upshot of that provision, Ed, is it takes the executive out of the ambit of just being a regular old at-will employee. You could be fired for a good reason, a bad reason, or my favorite, no reason at all. Rather, in that sort of contractual setting, the executive can only be terminated for just cause. Now, if there's no definition in the contract of just cause, Texas law essentially says just cause is any act in which a reasonable employee would understand that committing that act makes the employment relationship no longer tenable. Now, in employment agreement negotiations, employee executives would be well served, and so of course with employers, to have experienced counsel help them draft those provisions, because a just cause provision can be very broad and favorable to the employer, or it can be very narrow, like only on a criminal conviction or something like that, in favor of the executive. So that language is critical. The last thing is the case law in this area, like I said, pretty much says if there's no definition, it's a fact question for the jury, and most of these cases do become fact questions for the jury, not something the judge can decide. Only the judge can decide it, maybe on a summary judgment motion, if the executive committed some fairly egregious act of misconduct and admits to that act. Otherwise, it's going to go to the jury.